Let's take a look at constructive discharge. Disputes over whether an employee quit or was fired are not uncommon. If an employee truly resigns of his own volition, the employee cannot sue for wrongful termination. However, an employer cannot get around the law by creating intolerable working conditions designed to force an employee to quit, a scenario known as constructive discharge. If, under the circumstances, a reasonable person would have felt compelled to quit, courts will construe the resignation as a termination, and a claim for wrongful termination can still be brought. Factors that courts examine to determine whether an employee who resigned was constructively discharged include demotions or cuts in salary, reductions in job responsibility, harassment or humiliation calculated to encourage resignation, offers of early retirement on unfavorable terms. A resignation that occurs when an employee is presented with the stark option of resigning or being immediately terminated can constitute a constructive discharge. Courts consider in these cases whether the employee was given any alternative to resignation, was allowed a reasonable amount of time in which to make a choice, and was permitted to select the effective date of the resignation. Constructive discharge is not a wrongful discharge claim in itself. Instead, a finding that an employee was constructively discharged allows the employee to bring any legal claims that would be available had she been formally terminated. The nature of constructive discharges and the incredible lengths to which some employers go to drive employees out lends itself to another legal claim. One strong possibility is harassment, another is infliction of emotional distress. Clearly, employers should not attempt to avoid terminations by creating intolerable conditions designed to force employees to quit, nor should employers attempt to obtain resignations when terminations are already impending. Attempting to force employees out might give rise to additional claims of harassment or infliction of emotional distress. To understand termination of most private sector non-union employees, it's useful to distinguish between employment at will with exceptions, and just cause due process as legal standards governing termination. Under pure employment at will, there is no such thing as a wrongful termination. An employee without a contract for employment for a specified term can be terminated at any time for good reason, bad reason, or no reason at all. The opposite end of the spectrum, in terms of the ease in which employers can terminate employment relationships, is represented by the just cause and due process standard. Under a just cause due process standard, employers bear the burden of proving that terminations were carried out properly and were based on good reason. However, if the employer cannot adequately defend a challenged termination, that termination is deemed wrongful and the employee is entitled to reinstatement, back wages, or other remedy. In contrast to pure employment at will and just cause due process, most private sector, non-union employees have their employment relationships governed by a legal standard that can be best described as employment at will with exceptions. Under this arrangement, employment at will is still the starting point for analyzing an employee's right not to be terminated. Terminations can be challenged on constitutional, statutory, and common law grounds. Common law grounds include both contractual and tort claims. It is important to keep this menu in mind when analyzing the legality of a termination. Some protections are available only to public sector employees, unionized employees, and other employees not employed at will. What remains is considerable, although the various protections overlap and states vary in terms of whether and how practical legal protections are recognized. To simplify matters greatly, the exceptions to employment at will for most private sector, non-union employees boil down to the following impermissible grounds for termination. Terminations that would breach an implied contract, terminations that interfere with the exercise of statutory rights, and terminations that are discriminatory. A small number of employees have contracts of employment that are negotiated, executed in writing, signed, and specify a particular term of employment. If an employee with an express contract is terminated Prior to the expiration of the contract, the employer will be liable for damages for breach of contract unless the employer can show that there was cause to terminate. Most often, contractual disputes of this type are settled by negotiations between the parties. In contrast, the vast majority of employees do not have express contracts of employment and are employed at will. Nevertheless, under the implied contract exception to employment at will, the right of employers to terminate at will can be limited by promises of job security. Even in the absence of an express contract of employment, written or oral statements by employers can give rise to enforceable contractual rights to something other than employment at will. This might be employment for a specified term, or termination only for certain reasons. If an implied contract exists, discharged employees can sue for wrongful termination based on breach of the implied contract. Most statements made by employers, whether orally or in writing, are not contractually binding. However, the following factors point to the existence of an implied contract. A specified promise was made. The promise was made frequently and consistently. The source of the promise was someone with sufficient authority to offer it. The promise was communicated to the employee. The promise was not highly conditional. The employer's course of conduct was consistent with the promise. There was an exhaustive list of dischargeable offenses in a handbook. A change to the less protective policy was not communicated to employees. There was no effective disclaimer. Statements such as, "You have a promising future with the company," or "You will have a job here as long as we are pleased with you," do not evidence intent to depart from an employment at will and are unlikely to be enforceable. Listings of dischargeable offenses can limit employment at will if they can fairly be read to restrict terminations to those based on the stated set of reasons. To understand whether a promise was made, some courts look not only at statements spoken by managers or written documents, but also to the entire course of an employer's conduct. The course of conduct relevant to determining the existence of an implied contract includes the employer's informal policies, past practice, industry customs, and treatment of the individual employee. However, although consistent raises, promotions, and positive performance appraisals can bolster an employee's claim that employment is not strictly at will, they do not themselves constitute contractual guarantee of future employment security. Specific promises made to employees regarding their term of employment, permissible reasons for termination, or termination procedures must be honored. Because they're often cited by plaintiffs as sources of implied contracts, handbooks, application forms, and other job offer letters or communications should be carefully written and vetted by people with legal expertise before they're put into use. If changes are made that lessen employees' rights not to be terminated at will, employees should be clearly informed of these specific changes. Employment at will is a harsh arrangement. It's difficult to put a positive spin on the message that you can be fired at any time for any reason not specifically prohibited by law. Most employers prefer to gain the motivational and employee relations benefits that come from communicating the desire to treat employees fairly. Most employers probably also intend to treat employees fairly. Even so, employers do not want to be bound by promises of fair treatment and liable for breaches. In short, most employers would like to have it both ways. Disclaimers are used to this end. A disclaimer is a written statement incorporated into employee handbooks or other important documents that denies any statements in those documents create contractual rights that are binding on an employer. Language disclaiming the existence of a contract is typically combined with notification to employees in clear terms that their employment is at will. Disclaimers also frequently include language denying the contractual effect of any conflicting statements made elsewhere, reserving the right of the employer to modify policies and placing that authority solely with designated individuals. But do disclaimers inserted in the midst of statements and other facts suggesting a departure from an employment at will actually shield employers from wrongful discharge suits based on implied contract? In many cases, the answer is yes. Employers that desire to maintain employment at will should incorporate disclaimers into employee handbooks and other important documents defining the employment relationship. Disclaimers often defeat contractual rights flowing from handbooks and other sources if the disclaimers themselves are clear and unequivocal, and if they're presented to employees in a prominent and conspicuous manner. A disclaimer placed on the first page of an employee manual, capitalized and printed in bold, is both predominant and conspicuous. Fine print buried in lengthy documents is not sufficient. Disclaimers should be communicated to employees, and employees should be asked to acknowledge their receipt in writing. Disclaimers that are included on applications for employment so that employees know the terms of the relationship up front appear to be especially effective. However, disclaimers, even those carefully crafted and prominently displayed, are not foolproof. Some courts have taken the position that interspersing of disclaimers and statements that appear to confer rights is inherently ambiguous. If it's determined that contractual rights limiting an employer's ability to terminate at will do not exist, an implied contract wrongful termination claim will fail. However, if contractual rights exist, it still remains to be proven that the employer violated those rights in terminating the employee. Courts have long read into contracts an implied covenant of good faith and fair dealing. As a type of wrongful discharge claim, the covenant of good faith and fair dealing pertains to terminations that are undertaken in bad faith and have the effect of denying employees the benefits of their contractual employment relationship. This term is potentially misleading, however. It does not amount to a general requirement that employers operate with good faith or terminate employees only for cause. Instead, in most of the states where it's recognized, the covenant applies only where there is an express or implied contract and the employer has used a termination to deprive an employee of an already earned benefit. Another contract-related claim occasionally raised in discharge cases is promissory estoppel. The key elements are reasonable and detrimental reliance on a clear promise. A third contract-related claim, but one for which tort damages are available, is intentional interference with a contractual relationship. This occurs when intentional, improper interference causes a third party to breach or not enter into a contractual relationship with the plaintiff. A variety of laws protect employees against terminations that are in retaliation for actions supporting public policy or that interfere with the employee's rights under the law. Plaintiffs must show three things. First, that a clear public policy existed relevant to their conduct. It's the clarity element. Second, that discouraging the conduct in which they engaged would undermine this public policy, the jeopardy element. And finally, the causation element, which is engaging in conduct supporting of public policy that resulted in termination. Plaintiffs establishing these elements will prevail unless the defendant is able to show that there is an overriding justification for the termination. These include common law claims for wrongful discharge, whistleblower protection statutes, anti-retaliation and non-interference provisions in employment law and civic duty laws. Employees are also citizens with rights and responsibilities to the larger society. Sometimes, the roles of employee and citizen conflict. Employers occasionally want their employees to act in ways that are contrary to the public good. Under the public policy exception to employment at will, employers are liable in tort for wrongful discharge when they terminate employees for taking actions that public policy requires or highly commands. Allowing the terminations to stand would offend and undermine important public policy. Courts insist that claims be firmly grounded in fundamental and well-established public policy. To be protected, employees' actions must pertain to the public or society at large, rather than merely their personal interests or internal company matter. Primary sources of public policy are statutes and constitutions, although regulations, court decisions, and even professional codes of ethics are sometimes recognized as grounds for public policy claims. Although constitutions are the most basic source of law and public policy, courts have generally not permitted private sector employees to use constitutions as the basis for public policy claims. The jeopardy element suggests that even when an employee's actions relate to a clear public policy, the employee will not be protected unless allowing the termination would tend to undermine the public policy in question. Courts will inquire into whether alternative means exist to promote the public policy. The causation element is common to any type of retaliation claim and would be satisfied as evidence regarding the timing of the termination and other indicators of a motive of retaliating for the action taken in support of the public policy. If an employee can establish that the first three elements are true, an employer can still prevail by showing that the termination was also motivated by another overriding factor. Employees must not be terminated for refusing to commit illegal acts, exercising their legal rights, performing important public duties, or reporting illegal activities of employers to their agents. The first case in which a public policy exception to employment at will was recognized involved the termination of an at-will employee for refusal to commit an illegal act. Public policy wrongful discharge claims are also recognized when employees are terminated for exercising legal rights. Successful claims have been raised by employees fired for such things as filing workers' compensation claims, exercising their voting rights, and having wages withheld or garnished for child support. The most nebulous and least often recognized variety of public policy claims is termination for performing a public duty. The duty in these cases is something that is not strictly required by law, but is clearly undertaken in the public interest. This last type of public policy claim is termination for reporting illegal activity or whistleblowing. Whistleblowers report activities engaged in by employers or their agents that are illegal or otherwise injurious to the public. Whistleblowers also enjoy protection under a variety of statutes. Most states have whistleblower protection laws, although some of these statutes apply only to public sector employees. Some whistleblowers are protected under laws that pertain to specific safety-sensitive industries, including aviation and nuclear power. In addition, a variety of federal environmental laws incorporate whistleblower protections for employees reporting environmental violations by their employers. The Occupational Safety and Health Administration has been charged with the enforcement of more than 20 different federal whistleblower statutes. Whistleblower protections for employees who bring to light financial wrongdoing in their companies have been the focus of recently enacted laws. Federal government employees are covered by the Federal Whistleblower Protection Act known as the WPA. The WPA prohibits taking or failing to take a personnel action because an employee or an applicant has disclosed information that is reasonably believed to show a violation of the law, rule, or regulation. It also applies to gross mismanagement, gross waste of funds, abuse of authority, or a substantial and specific danger to public health or safety. The definition of protected reports is relatively broad under the WPA because the internal affairs of federal government agencies nonetheless concern the public. The Act's prohibition against retaliation is also broad, extending to decisions to order psychiatric testing and any other significant change in duties, responsibilities, or working conditions. Whistleblowers are entitled to protection under the WPA, regardless of whether they were first persons disclosing the particular misconduct, their reports were not in writing, or they were off duty at the time. One other federal whistleblower law deserves mention. The False Claims Act applies to individuals who come forth with information about a knowingly false or fraudulent claim made against the federal government. This law allows the Department of Justice to join in suits to recover the amounts of money lost through fraud or individuals to sue on behalf of the government. Because these cases often involve large amounts of money, and the Act allows recovery of 3 times the actual damages to the government, whistleblowing under the False Claim Act can be lucrative. The False Claim Act also protects employees against retaliation based on their investigating or otherwise pursuing actions intended to uncover fraud against the federal government. Employees whose normal job responsibilities include making reports to their employers about issues that are the subject of whistleblower claims must show that their actions went beyond just doing their job. It is important that the plaintiff can show that the employment decision maker was aware of the whistleblowing or investigative activity. The False Claim Act reaches cases of retaliation against an employee who reports fraud against the government that is engaged by a party other than the employer itself. A number of statutes protect employees against discharge for engaging in specific civic duty laws. One of these civic duties is jury service. Under the Jury Systems Improvement Act, permanent employees are protected from termination because of their service on federal court juries. Most states have similar laws covering employees who serve on state juries. Another important civic duty is military service. The extensive reinstatement rights of veterans under the Uniformed Services Employment and Reemployment Rights Act exist. A significant addition to these rights is the uniformed service members who are reinstated cannot be terminated without cause for specified periods of time. Most employees believe that their personal lives off the job are none of their employer's business and certainly not something that should affect their employment status. Approximately half of all states have off-duty conduct laws on the books, though the reach of these laws is limited. Most of the statutes protect employees only for their use of tobacco and other lawful products when off the job. In states with these laws, smokers cannot be refused hire, terminated, or otherwise discriminated against, although they need not be allowed to smoke in the workplace. Elsewhere, it is legal for employers to discriminate against smokers if they so choose. Terminations based on the protected class characteristics of employees, no less than any other adverse employment actions, are discriminatory disparate treatment. However, some modifications are required to apply the methodology for analyzing disparate treatment cases to terminations. Alleged inconsistency in applying discriminatory rules is frequently a central issue in discriminatory discharge cases. Under employment at will, employers do not have to be fair, just, or even correct in their administration of discipline, but employers cannot treat some employees more harshly than others based on their protected class characteristics. Evidence of unequal discipline under similar circumstances strongly suggests that something other than employee conduct is behind different outcomes. Courts differ in terms of how strictly comparable the situations of employees must be to show that they're sufficiently similarly situated to serve as evidence of disparate treatment. The same evidence of unequal discipline given to similarly situated employees used to establish a prima facie case can also be used for purposes of demonstrating pretext. However, some courts have differentiated between the comparator evidence needed to establish a prima facie case and that needed to establish pretext. One of the best ways to avoid discriminatory termination is to enforce policies in a consistent manner, treating like situations in a like manner regardless of those involved. Employees regularly overestimate their rights in the workplace. Commonly, employees believe that they have legal protection not to be fired without good reason. Non-union, private sector employees can be terminated for any reason that is not specifically illegal through the use of whatever decision process the employer deems appropriate. However, the distinct legal status of unionized employees comes from language in labor agreements that limits discipline and discharge to situations in which there is just cause. Grievance procedures in unionized workplaces almost always provide for the arbitration of grievances that are not otherwise resolved. Arbitrators determine whether employees have been terminated for just cause. Arbitrators are typically given broad authority. If an arbitrator decides that a discharge was not for just cause, the arbitrator can overturn the disciplinary action or modify it to provide for a lesser penalty. Just cause is clearly a central concept in understanding the legal rights of unionized employees. Arbitrators generally consider the following factors to determine whether employers had just cause to discipline or discharge. Arbitrators are concerned that employees have prior notice that their behavior will be subject to discipline or discharge. Typically, this requires that unionized employers establish rules, standards, and policies that communicate these to employees. Policies become real and enforceable not merely by being formalized and communicated in some fashion to employees, but more importantly by being consistently enforced. Unionized employers must clearly communicate changes in policies before attempting to enforce new, more stringent standards. Although employers have the right to establish rules, arbitrators ask whether challenged disciplinary actions are based on reasonable rules related to efficiency, safety, and other important business purposes. Grievance procedures and arbitration provide for substantial due process following termination. However, arbitrators typically require that elements of due process be present before termination decisions were made. Unionized employers must adequately investigate alleged misconduct, notify employees of charges against them, provide employees with a chance to respond to those charges, and respect the Weingarten rights of employees. To have just cause, the investigation must produce sufficient evidence that the accused employee is actually guilty of wrongdoing. The employer bears the burden of proving a violation. Arbitrators view discipline as corrective rather than punitive. Although some offenses are so serious that they warrant termination following a single occurrence, arbitrators generally expect to see progressive discipline. Progressive discipline entails making a genuine effort to correct undesirable behavior, not just going through the motions and creating a paper trail before terminating an employee. Finally, mitigating factors are considered when imposing discipline. Mitigating factors do not affect the finding that an employee did something wrong, but can cause the arbitrator to reduce the severity of the penalty. Potentially mitigating factors include the employee's past record, length of service, compelling personal or medical problems that might explain the behavior, and situational factors. Unionized employers should carefully consider these just cause factors when making discharge decisions. These criteria provide excellent guidance for making reasonable and legally defensible termination decisions. Unionized employers that fail to substantially meet these criteria can expect that their termination decisions will be challenged and most likely not upheld in arbitration. Most cities, counties, and states, as well as the federal government, have civil service laws that are intended to ensure that merit guides employment decisions. Besides specifying job classification, testing, hiring, and promotion procedures for public employment, civil service laws usually incorporate processes for review of disciplinary decisions. Often, these laws provide that non-probationary employees can be terminated only for cause. The Civil Service Reform Act covers most federal government employees. Disciplinary actions, including terminations, can be appealed to the Merit Systems Protection Board, known as the MSPB. The federal agency imposing the discipline bears the burden of showing, by the preponderance of evidence, that the alleged misconduct actually occurred and that the penalty is reasonable in light of the severity of the offense. Tenure recognizes some unique facts of academic life. Tenure makes a relatively low-paying occupation that requires considerable investment in education a bit more attractive. It promotes development of a stable, experienced faculty with strong commitment to their schools and communities. Recently, law established civil service protections for public employees, and tenure laws have come under increasing challenge. The U.S. Constitution requires that due process be provided before the government can deprive individuals of property rights. The 14th Amendment says, in part, that states shall not deprive any person of life, liberty, or property without due process of law. The 5th Amendment places the same restriction on the federal government. Most, but not all, public employees can be said to hold a property interest in their job. The existence of a property interest is defined by state laws, employment policies, and express or implied contracts. One police department manual approved by city officials stating that discipline shall be for cause and follow the basic concepts of due process was sufficient to establish a constitutionally protected property interest in continued employment. In another police department, regulations permitting the termination of probationary employees for any reason, but remaining silent with respect to non probationary employees, did not establish a property interest. The Supreme Court has considered the nature of due process to which public employees with a property interest in their jobs are entitled prior to termination. Although a pre termination hearing need not be elaborate, the public employee is entitled to oral or written notice of the charges, an explanation of the employer's evidence, and an opportunity to present their side of the story prior to discharge. Public employees are also sometimes deemed to have a liberty interest that is jeopardized through termination. The focus of this interest is on maintaining the employee's good name. The charges that are the basis for termination must be stigmatizing, like theft or drug use, false, and made public without a meaningful opportunity for the employee to clear their name. In general, public employers are responsible for affording their employees due process both before and after termination. Following termination, a more elaborate hearing with opportunities to confront witnesses and present evidence is required if requested by terminated employees. Public employees, like other citizens, have rights under the First Amendment concerning the manner in which they are treated by the government. These rights include freedom of religion, speech, and association. Terminating or otherwise disciplining employees for exercising these rights is unconstitutional. But because the relationship between the government and individual citizens is a different consideration, a more delicate balancing of constitutional rights and the government's prerogatives as an employer is required. Constitutional protection against termination or other disciplinary actions based on public employee speech depends, first of all, on whether the employee was speaking as a citizen or as a matter of public concern. Speech is a matter of public concern and is potentially protected when it pertains to political or social matters that concern the larger community. Public employees who speak out in this way still might not be protected from termination or other discipline if their employer's interest in efficiently and effectively delivering services outweigh the employee's speech rights. Speech that harms supervisory relationships, promotes lack of harmony in the workplace, has a detrimental effect on close working relationships, or renders employees unable to perform their duties will not be protected. In other words, the public employee's speech rights are balanced against the public employer's interests and the effects of the speech. Termination or other disciplinary action should be imposed only when the exercise of these rights clearly interferes with an employee's ability to do her job or with accomplishment of the public agency's mission. Public employers must respect the constitutional rights of public employees, including their freedoms of religion, speech, and association. Employers often attribute terminations to poor performance by employees. Even though at-will employees can be terminated for poor performance without supporting evidence in performance appraisals and other documents, it's highly advisable for employers to document employee performance. Such documentation, if credible, helps establish that performance issues cited as grounds for termination are not pretexts for discrimination or other illegal motives. To be credible, all employees within the same job category should have the opportunity to have their performance evaluated and to receive feedback on their performance. Courts generally have not recognized negative performance appraisal ratings in and of themselves as adverse employment actions on which discrimination charges can be based. Performance criteria and standards must be applied in a consistent manner. Using double standards to evaluate members of a different protected class group is clearly disparate treatment. Performance appraisals inherently involve an element of subjectivity. To lessen the chance of disparate treatment, performance criteria should be as objective as possible. Job performance is multifaceted, so ratings should consider different dimensions of performance. It's also important to have criteria that are established and known to employees beforehand. Although most cases involving performance appraisals allege disparate treatment rather than adverse impact, performance appraisal criteria should be related and consistent with business necessity. Performance ratings that suddenly diverge from established track records of performance are apt to attract judicial notice. This is particularly true when it occurs shortly before a termination. Performance appraisals should be written mindful that they might become evidence in a subsequent legal proceeding. Appraisers do not have to shy away from criticism, but their tone should be measured and professional. Under a performance improvement plan, known as a PIP, an employee is given outcomes that must be attained over some period of time, with specified negative consequences if desired performance is not forthcoming. It's a good idea to try to correct performance problems before they become too serious and require termination. Even when employed at will, employees cannot be terminated for illegal reasons. A wrongful termination claim cannot be brought without a termination or constructive discharge. Alternatives to termination, including retraining, transferring, demoting, or suspending, should be considered. To the extent that these are adverse employment actions, they still present legal concerns, but they're less apt to be challenged than termination. Last chance agreements are sometimes a viable alternative to termination and are generally taken seriously by both arbitrators and courts in the event of subsequent transgressions by the employee. The option of written voluntary resignation agreements can be pursued when there are growing concerns about the performance or conduct of an employee, but a termination is not yet imminent. Termination decisions should receive careful internal higher level review. Terminations tainted by discriminatory or retaliatory motives are particularly likely to be identified by this type of dispassionate internal review. Termination decisions should not be made on the spot by single individuals. Employees should be placed on administrative leave if circumstances warrant their removal prior to the completion of an investigation. Employers do not have to be correct about their reasons for terminating at-will employees, but an employer without good documentation of the reasons for a termination will be at a disadvantage in defending against wrongful discharge claims. The reasons for termination decisions and the process followed should be solidly documented. Materials should be in writing, produced prior to the termination decision, and support the decision to terminate. Provide employees with a clear and succinct statement of the reasons for their termination. Employers should generally avoid making public statements about terminated employees and the reasons for their terminations. There is no way to make terminations pleasant or comfortable. Instead, the aim is to communicate the reality of termination without any ambiguity and in a reasonable, dignified manner. Employees should be notified of termination in person. The meeting should be brief and occur in a private setting, away from the view of coworkers. If possible, the meeting should not occur at the end of the week or immediately before a holiday. Unless there are compelling security reasons, terminated employees should be allowed a reasonable amount of time to clear out their offices and take care of other business rather than be ushered out of the workplace. The fact of termination should be clearly communicated but not debated. Information should be provided regarding final paychecks and benefits. Final wages should be paid quickly and within any period provided under state law. Employees do not have a legal right to receive severance pay absent any contractual agreement to provide it. However, employers can consider offering severance pay in exchange for releases of legal claims related to termination. In general, releases of legal claims by terminated employees are enforceable. Such releases must be knowing, voluntary, and supported by consideration.